What's up, everybody? Welcome back to the Homie Hangout, where we help others move with excellence. And about a month ago, I did a video around the Second Amendment, right, and where gun laws were going in this country. A lot of people had asked about it. There was different cases in the news and all sorts of stuff. So basically, I put together a constitutional law course in the Second Amendment, but broke it down and made it pretty simple and posted that. And in return, like 1,200 people watched it, which was odd because I see other videos from folks outside the genre and they're getting half a million views talking about the same stuff. A lot of times with less detail or a lot more complicated and whatnot. So I said in the end of that video though that we were really waiting for the Supreme Court to make this particular decision by June 30th of this year, and that would really clarify where we were going in terms of who's going to get guns, who's not. Right? Obviously, I'm interested in this not just as somebody who follows the law, but also somebody who is a violent felon, right? And has firearm convictions. And so, anyways, let's get into it. I'm gonna pick this up right where I ended the last one, right? And we'll run through this. So here we go. New York Gun Association or whatever versus Bruen, right? 2022 case. This is where it all started. 6-3 decision, and basically these guys appealed to have a concealed carry permit, right? And they were denied. And New York had this law called the Sullivan Act dating back to 1911, which said, among other things, in order for you to get a concealed carry permit, you need to demonstrate that you have some special need for protection that is distinguishable, right? Is separate from that of the general community or even of other people in your same profession. And if you can't do that, then you can't get a concealed carry permit. And the result was effectively nobody got a concealed carry permit, right? And so the Supreme Court turned around and said that is unconstitutional. And two big things came out of it. The first was the difference between may issue laws and shall issue laws. And what that means is a lot of states, a lot of cities have regulations around permits, right? Permits for concealed carry, permits for handguns, period. And the Supreme Court said that those aren't necessarily illegal, right, or unconstitutional. But a lot of times, those permit processes are just a scam to not actually give anybody guns, right? So it says, hey, you check all these boxes and we may issue you a permit. Supreme Court said you can't do that. But you can say, hey, if you check all these boxes, we will issue you one, right? We shall do it. So think about a driver's license. If you go take your driving test and you pass the written test and you pass the driving test, you get your license, right? It's not an issue of, well, actually, no, I don't really feel like it, right? You have that coming. They said that permit requirements for guns that follow that same kind of model would possibly be okay. And then the other big thing that they said was, in the big change, right? That really threw a lot of states and lower courts, kind of for a loop was when the Second Amendment plain text covers an individual's conduct, here the right to bear arms, the Constitution presumptively, meaning just on the surface from jump, protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. And that's that historical tradition part that really threw a lot of stuff off, right? And led to a lot of appeals and everything else. And it was interpreted that, hey, if you can't find gun laws which existed in the 17th century, 18th century, right? And you can't find a law now that is similar to a law then the law now must be unconstitutional, right? It doesn't follow the historical tradition. And the government has the burden of outlining what that history is. It says only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So again, that led to a bunch of cases. And the one that we're waiting to get a decision on is this one, right? U.S. versus Rahimi, 2024. It was actually decided just like a week ago, and it was an 8-1 decision, which is pretty rare, especially with the Supreme Court. And I'll get into what they said. But just a reminder what the Rahimi case was. Rahimi is this jackass from Arlington, Texas, and he had been threatening his old lady, dragged her out to the car, smacked her into the dashboard. Um, the neighbors came out and was like, "Hey, fool, what are you doing?" He wound up popping at the neighbors. And she wound up, then he called her and threatened her, right? If you tell the cops, I'm going to do this and do that. A lot of that involving a gun. She wound up telling the cops anyways, and she got a domestic violence protection order, right? And that meant that this individual, Rahimi, was not allowed to own guns. Now, Rahimi goes on in road rage. He's popping at everybody, right? He's a clown, right? He's a jerk. And eventually, cops go and search his house as they're investigating these other kind of just wild old men running around shooting at people. And they find that he has firearms. And so, since he had the protection order, he wound up getting 6 years in the feds for violating that domestic violence protection order. The Texas court was like, yeah, off top. But then after that Bruen case that I just told you about, right, that we just talked about, his dude Rahimi turns around and says, no, no, no. There was no laws against domestic violence back then. So therefore, you can't have any laws against domestic violence that infringe on my Second Amendment rights now. And and so they said, hey, let's wait for the Supreme Court. And the Supreme Court said they would rule by June 30th, right? Which they did. So what did the Supreme Court say? Um, they said that considering the constitutionality of restrictions on gun rights must determine, courts considering the constitutionality of restrictions on gun rights must determine whether the new law is relevantly similar to laws that our tradition is understood to permit, applying faithfully the balance struck by the founding generation to modern circumstances. That was the Chief Justice, right? So that is how the court wound up ruling, right? He wrote the majority opinion. Now, some of the more liberal justices, Sotomayor, Kagan, they wrote their own opinions because they agreed, but they really don't like Bruen, the actual decision that led to all this confusion. And people had different opinions. Clarence Thomas is the only one who dissented, and he's not really to be taken too serious in this conversation, right? But so what Chief Justice said, and what all the justice effectively said was, there are laws from the founding of the country that do prohibit dangerous people from having guns. They had these laws on the books, and you could be charged with going armed, right? In other words, arming up, strapping up with your little muskets and shit, and mobbing down the street with the intention to go commit harm on people. The cops could bust you for that, right? Even back then. And if you were believed to be a dangerous person, right? If you were a drunk dude always throwing stuff around or pulling weapons on people, you could get snatched up and have to post bond. And so the court said there is a historical tradition of viewing dangerous people as not being able to have firearms, having their Second Amendment rights suspended, at least for a period of time. Now, what that period of time is going to wind up leading to a lot more stuff. So nonetheless, Rahimi still got to do his time, right? His argument, and he had other kind of legal arguments in there that made even less sense. But so let's look in light of that at some of these cases, right? So you have the DWarte case. I had mentioned this in my last video. Shorty, right? This guy's nickname is Shorty, from Southern California. He has 5 prior nonviolent felonies, right? Vandalism, dope, felon in possession of a firearm, and evading the police, right? The feds gave him 51 months for evading and a felon in possession of a firearm. The Ninth Circuit said that his felonies would have been misdemeanors or non-crimes back in the 1700s. So that part is probably accurate, right? But what about the violent part? Well, in his case, he doesn't have any violent felonies, right? So he hasn't really demonstrated himself to be a violent danger. I would expect for this now, based on the Supreme Court decision in Rahimi, I would expect Shorty from Southern California to get some action. I really think it's looking good for non-violent felons, right? Another case that is out there right now. Garland versus Range. So this dude Range, he lied to get food stamps, right? This was in Pennsylvania. He lied about his income in order to get food stamps. He was facing 5 years in prison for it, which I don't know, you can get that much time. He wound up pleading guilty for 3 years probation, right? So he didn't do any time. But again, as a felon, he can't have guns. The Third Circuit said that the Justice Department did not show any historical tradition to support bans, um, that are similar to this, right? And so Biden actually asked the Supreme Court to hear this case and asked them to hear a few cases. And the Biden administration, the Justice Department, when the Third Circuit said this, got at the Supreme Court and said, "Hey, uh, if you let this ride, then all kinds of people who have different convictions and different criminal histories, violent, non-violent, this and that, everybody's going to want us to look at their particular circumstances when determining whether they have Second Amendment rights intact or not, right?" And so this is one of the cases that the Supreme Court said just, yesterday, I think, hey, we're going to kick this back to the circuit court. Now that we told you in Rahimi that it doesn't have to be historically identical, it just has to resemble the spirit of regulation that existed in the early days of this country in order to kind of pass muster now, then go ahead and look at this again. And I think Garland, again, has action, right? Here's another case, U.S. versus Daniels. And this one is really interesting to the Biden family. Daniels was pulled over for not having a license plate on his car. The cops said they smelled weed. They looked around. They found some roaches. He had a loaded pistol and a loaded rifle. Feds, there's a law with the feds that you cannot have guns while consuming or using illegal drugs, right? This happened in 2022, I guess in Mississippi. Well, I guess, to the feds, weed is still illegal, but in particular in 2022. So the dude took it to trial, right? Took it to trial. He wasn't doing anything with his guns. He just had a loaded gun and a loaded rifle. He says, "Hey, I like to smoke weed. I smoke it at least 14 days out of the month for the past several years." But he didn't have a background. He took it to trial in Mississippi and lost and got 46 months in prison. The Fifth Circuit said that law violates the Second Amendment. I think that's questionable. I think he may have action, but I think that the circuit court, in looking at the Rahimi case, may turn around and say prohibiting people from having weapons when intoxicated, right, or is not such a bad thing in terms of historical tradition, because they did have laws back in the days about drunk people and guns. And so while I don't think that this makes sense, I don't think this is justice whatsoever that the dude got 46 months in prison. I do think that laws like that will probably hold up. Now, the reason Biden's in a bind is because, remember, he's telling the Supreme Court, "Hey, man, I need you to do something about this. These people with individual criminal histories shouldn't be doing this, man. We got felons and everything else." Well, his son, Hunter Biden, was just convicted of violating the same law as old boy Daniels, right? The having a loaded weapon when consuming drugs. And so it'll be interesting to see how this plays out. Obviously, if Hunter Biden winds up being able to walk and not face any consequences, people are going to say it's because his dad pulled strings, but really it's a Supreme Court decision. But his dad is in a bind because the Justice Department is arguing for less people to have guns, right? While also his son is in a spot. So we'll see how that goes. So last one, and again, these are all cases that have been pushed back to the circuit court by the Supreme Court, where they're told, "Hey, we're not going to hear any of this stuff, but we want you guys to reevaluate these specific cases in light of what we said. And let's see what you come up with," right? Now, in response to that New York one, right, that I told you about before, the Sullivan Act one, right? So in response to this, way back in 2022, the Bruen case, the New York assembly, legislature, state law, and the mayor came up with this just dummy of a thing. Concealed Carry Improvement Act of 2022, right? Emergency legislation, based on the Bruen decision. And they said, okay, our permit, process for concealed carry, this is how we're going to fix it. Among other things, in order to get a permit, you need to be somebody of good moral character. And how they determine if you're good moral character is you have to go to this hearing, you have to provide references for at least 3 people who are willing to testify to your good moral character. It's a very intrusive background test, very much an invasion of an individual's privacy, right? In order to determine if you're able to get this permit. And they say historically, this is based on post-Civil War laws, right? And I'll get to kind of the crazy, racist, twisted logic of this shit in a second. They also said even if you get the concealed carry permit, there's a whole bunch of sensitive places that it doesn't apply, right? Churches and schools and houses of worship and stadiums and all that other stuff. But they also said including on private property, unless the owners of that private property have it visibly posted that they are okay with people concealed carrying permits there. So in other words, if this was to be enacted, right, which is highly questionable, almost impossible, right? But if this was to be enacted, what the New York mayor and state legislature wanted was I get a permit to carry a gun, right? But I can't bring it to your house unless you have a sign out front, like those ADT signs or something. I don't know what the fuck the sign would look like, but unless you have a sign out front, visitors to my house are allowed to keep a pistol in their pants. If you don't have that sign, and I go to your house with the gun, I walk out your front door, I can wind up being arrested, even though I have a concealed carry permit. So it just didn't make sense. And they said that the historical tradition that supported that kind of policy was in the 18th century, they had bans on hunting on private property, right? And so somehow they drew this correlation, right? This connection. So the Second Circuit in New York blocked it at first. Then they looked at it again and said, we're going to block part of it. Then they looked at it again and said, we're just going to wait for the Supreme Court, right? So in the process of all that, this dude sues, right? Ivan sues. And this is another case that the Supreme Court said they want their circuit court in New York to look at again. So Ivan and Tanayuk, we're going to call him Ivan. Ivan argues that Concealed Carry Improvement Act should be tossed because the proper period to look at is the 18th century, right? When the Second Amendment was ratified, not the 19th century when the 14th Amendment was ratified. And what he's getting at there is the 14th Amendment, a big part of that, right, which we call the Equal Protection Clause, a big part of that was because the KKK was preventing black people from having guns, right? Just to keep it a buck, right? And they were saying that the Second Amendment didn't apply to black people, right? It only applied to white people. So post-Civil War, the Equal Protection Clause, one of the things that it allowed was for people of other races to be able to enjoy the Second Amendment, right? And the response to that by a lot of states was all these permit laws. That's where these good moral character and that kind of stuff, that's where those laws come from. You can't have guns in certain places. You can't have guns unless you're a decent human being. And we'll decide who's a decent human being. So we're not going to prohibit black people from having guns, but we're going to prohibit people that we don't think are of the right moral character from having guns. And oh, by the way, we don't think black people are capable of having good moral character. So it's a roundabout way to still deny them the ability to have guns. The fear is black folks have a history in this country, in particular in the South, and white people have always been scared. Not always like today, but back in the days, white people were always scared that if you gave black people guns, they were going to use the fucking guns on the white people, and and it wouldn't turn out well, right? Probably because most of them acknowledged that if they had to endure those same conditions, they would definitely be getting guns and trying to get their freedom too. So this dude, right, is saying, no, 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 no. The laws have to match with the 18th century, right? When there wasn't moral character stuff. You don't apply it to the 19th century because after that you have equal protection. And we don't want to talk about the laws that follow equal protection. I'm not saying that this dude Ivan is racist whatsoever. I don't know the guy. Or that he was even thinking about black folks or brown folks or any other disfavored group, right, in the eyes of the authorities. It's just interesting. I thought maybe some of you guys would get a kick that all these laws that we have now around what type of people can have guns, who can and who can't. Those laws were actually a response to uh, allowing minorities and other people that you didn't like to have guns, which was forced after the Civil War, right? And again, the 14th Amendment. So it applies. Equal protection applies a lot farther than that, of course. But that was something that's not talked about much today. But that was a central part of the Equal Protection Clause. The 14th Amendment, in effect, made the Second Amendment possible for Black people, and so yeah, that's where we're at, right? I think nonviolent felons stand a good chance of um, of getting firearms back, right? I think that lifetime bans on firearms, um, for people, right? So a permanent uh, denial of your Second Amendment rights. I think those are going to be going away, and I think they're going to be going away soon, because the Supreme Court did allude to that. Um, there's also some question, and I think it's going to come up later. Sotomayor brought it up in her opinion, right? Was what about kind of the cultural factor, right? So laws and this issue that I just mentioned really kind of highlights that laws in the founding of this country, right? Um, really were there to benefit uh white males, right? There weren't laws to that really gave a shit about women or gave a shit about minorities or gave a shit about kids or gave a shit about anybody else, right? So if you have to find laws that are similar to back then, there's a whole group of people that are really weren't protected by the law in the 1800s in this country, right? And so how are you going to find, similar laws? So there's a lot of different opinions from a lot of different people, a lot of different, judges about where this might go. But I think that the clarity that you don't have to find some exact law from back then to have a law now, but it has to match the spirit of it. Did people around the time of the Second Amendment, did lawmakers in this country think, hey, here's something we need to keep an eye out for, man. People like this should not be able to have guns, right? People like this, shouldn't be able to be drunk and walk down the street with a rifle at the same time, right? So that gives you an idea of what their concerns were. And is that type of behavior, although it may look different now because society has changed, is that still a thing? Drunk people walking around with guns is still a thing, right? So I think that clarity is going to fix a lot of the stuff. I expect someday, hopefully in my lifetime, that myself, as a violent felon who shot somebody at the age of 19 and went to prison for it, that I will one day be able to get my gun rights back. We will see. It remains to be seen. Anyways, like, share, subscribe. Rascal Reacts is back. And so I appreciate you guys showing some support to that channel. I talked about Flacco and his incarceration this morning. And the volume was pretty low again, but I think it got fixed. So yeah, I appreciate you guys. Help others move in excellence. That's what homies do. Help yourself at the same time because you're worth it. Help your community because they need you. And I'll be posting consistently, man, all month. I'm kind of done going to California for a while. So you guys take care.